Hi. Okay, let's start out with a 10-minute at 200 jury charge. 10 minutes. So this will be a nice little endurance take for you. 10 minutes straight through at 200. Ready? Members of the jury, it now becomes my duty to tell you the law that applies to this case. And it is your duty, as I mentioned at the beginning of the trial, to follow the law as I stated to you. Before I tell you the law, however, let me make some general comments about your responsibility as jurors. You have been chosen from the community to make a determination of the facts in this case. What the community expects of you and what I expect of you is the same thing that you would expect if you were a party to this suit, an impartial deliberation and conclusion based upon all the evidence presented in this case and on nothing else. You must deliberate on this case without regard to sympathy, passion, or prejudice for or against any party to this suit. This means that the case should be considered and decided as an action between persons of equal standing in the community. A corporation or an insurance company is entitled to the same fair trial at your hands as a private individual. All persons stand equal before the law and are to be dealt with as equals in a court of justice. Above all, the community wants you to attempt to achieve justice, and your success in that endeavor depends upon the willingness of each of you to seek the truth as to the facts from the same evidence presented to all of you, and to arrive at a verdict by applying the same rules of law as I give them to you. If during this trial I have said or done anything which has suggested to you that I favor the claims or positions of either party, you should disregard it. If I have indicated in any way that I have any opinion as to what the facts in this case are or should be, you should disregard that. I am not the judge of the facts. You are the judges of the facts. Before I tell you about the law, you should understand several things about my remarks. As I mentioned earlier, it is your duty as jurors to follow the law, as I shall state it to you. You should not be concerned with the wisdom of any rule of law that I may tell you about. You should consider what I say about the law as a whole. You should not single out any one sentence or individual point or idea and ignore the others. The order in which the statements about the law are made has no significance as to their relative importance. The first thing that you should know about the law is that the plaintiff in this action must prove his case by a preponderance of the evidence. This means that the plaintiff must convince you that when the evidence is taken as a whole, the facts sought to be proved are more probable than not. If he fails to prove or establish any essential element of his claim by a preponderance of the evidence, then you must find that he has failed to prove his case sufficiently to recover. There is no presumption that because the plaintiff has been injured or because he has brought this lawsuit, he necessarily is entitled to a recovery against these defendants. The evidence which you are to consider consists of the stipulated facts, the testimony of the witnesses, the documents, if any, that have been admitted into evidence, and any fair inferences and reasonable conclusions which you can draw from the evidence submitted to you. Neither the written pleadings nor arguments by the lawyers, nor any comment or ruling which I may have made, is evidence. A stipulated fact or stipulation is a fact that the attorneys agree is accurate. Since there is no dispute about certain facts, the attorneys may agree or stipulate those facts to save us all a lot of time in this trial. Unless I instruct you to the contrary, you must accept a stipulated fact as evidence and treat the fact which is stipulated as having been proven. A fact may be proven either by direct evidence or by circumstantial evidence, or perhaps by both. Direct evidence is testimony by a witness as to what they saw or heard, or physical evidence of the fact itself. Circumstantial evidence is proof of a certain circumstance from which you may infer that another fact is true. The law does not regard one type of evidence as preferable over the other. In judging the credibility of the witnesses which you have heard, you should have in mind the rule that the witness is presumed to speak the truth about facts within her knowledge. This presumption, however, may be overcome by contradictory evidence, by the manner in which the witness testifies, by the character of his testimony, or by evidence that pertains to his motives. As I mentioned to you at the beginning of the trial, when you weigh the credibility of a witness, you should consider the interest, if any, which he or she may have in the outcome of the case, their ability to know, remember, and tell the facts to you, his or her manner of testifying as to sincerity and frankness, and the reasonableness or unreasonableness of the testimony, in light of all the other evidence. If the testimony of a witness here in court is inconsistent with a prior statement he or she has made, it is your duty to determine if the testimony of the witness here in court should be discredited. If you decide that the testimony of the witness has been discredited, then you are to decide what weight, if any, to give to the testimony of the witness. If you should find that a witness has testified falsely as to a material fact, then you have the right to reject the entire testimony of the witness or to reject only part of the testimony based upon how you are impressed with the truthfulness of the witness. If the testimony of a witness here in court is inconsistent with the prior statement he or she has made, it is your duty to determine if the testimony of the witness here in court should be discredited. If you decide that the testimony of the witness has been discredited, then you are to decide what weight, if any, to give to the testimony of the witness. If you should find that a witness has testified falsely as to a material fact, then you have the right to reject the entire testimony of the witness or to reject only part of the testimony, based upon how you are impressed with the truthfulness of the witness. You are not bound to decide any issue of fact in accordance with the number of witnesses presented on that point. Witnesses are weighed and not counted. Your function is to determine the facts, and this is not done by counting noses. The test is not which side brings the greater number of witnesses before you or presents the greater quantity of evidence, but rather which witnesses and which evidence appeals to your minds as being most accurate and most convincing. I have mentioned to you that witnesses are expected to testify about facts within their knowledge. The rules of evidence ordinarily do not permit witnesses to testify as to their opinions or conclusions about those facts. An exception to the rule exists to those whom we call expert witnesses. These are people who, by education and experience, have become expert in some field and are permitted to state their opinions as to relevant matters in the field in which they profess to be experts, and give their reasons for those opinions. You should consider each expert opinion received into evidence in this case and give it such weight as you may think it deserves. If you should decide that the opinion of an expert witness is not based upon sufficient education and experience, or if you should conclude that the reasons given in support of the opinion are not sound, or if you feel that it is outweighed by other evidence, you may disregard the opinion entirely. As the triers of fact in this case, you may substitute your own common sense and judgment for that of an expert where, in your opinion, such substitution appears warranted by the evidence as a whole. During the trial of this case, certain testimony has been presented to you by way of written and video depositions, which are the recordings of sworn answers to questions asked of witnesses in advance of the trial by one or more of the attorneys for the parties in this case. The testimony of a witness who, for some reason, cannot be present to testify from the witness stand may be presented in the form of a deposition. Such testimony is entitled to the same consideration and is to be judged as to credibility and weighed and otherwise considered by the jury in so far as possible, in the same way as if the witness had been present and had testified from the witness stand. The law applicable to the plaintiff's claim depends upon the nature of that claim. The plaintiff seeks to recover under a theory of negligence. Under the Civil Code, such an act is called an offense, and the suit is generally termed a tort suit. This is a suit seeking damages for injuries caused by the act of another. The basic law in this type of a suit is found in Article 2315 of the Civil Code. Every act whatever of man that causes damage to another obliges him by whose fault it happened to repair it. The word fault in the article is a key word. While the Civil Code does not further define the word, it may perhaps best be explained by saying that it signifies that conduct which a person should not have engaged in, that is, that he has acted as he should not have acted, or that he has failed to do something that he should have done. It is thus conduct below the standard which the law applies to his or her activities. A driver attempting to make a left turn is under a duty to exercise a high degree of care. He or she is presumed to be liable for the accident and must prove that he or she is free of negligence to avoid liability. He or she must make sure before turning that the turn can be made without danger to oncoming traffic, and he or she must yield the right of way to such a vehicle. A left-turning driver has the duty to exercise a high degree of care even if the intersection is controlled by a left turn arrow. To discharge the burden of proving that he or she was not at fault in the accident, he or she must prove that he or she was making his or her turn while the arrow was green, or that he or she had preempted the intersection. Evidence in the form of moving pictures or videotapes must be approached with great caution because they show only intervals of activity on the subject. They do not show rest periods and do not reflect whether the subject is suffering pain during or after the activity. As I have previously told you, in order to be successful, the plaintiff must establish all of the essential elements of his or her case. The other elements are the following. 1. that the injury plaintiff suffered was in fact caused by the conduct of the defendants, and 2, that there was actual damage to plaintiff's person or his or her property. Our law contemplates a just and adequate compensation for injuries. Our law does not permit the awarding of damages to punish the defendants or make an example of them to prevent the other accidents, and you should include no such amount in your award. That was a nice little endurance bit for you. Pretty standard, a little bit different in the middle, but pretty standard. So if you're able to get this down pretty accurately, you're in good shape. Way to keep up the endurance. You should probably be pretty tired right now, but that's a good thing. Good job.